Respondents are raising the same contention that were raised, considered and rejected by the Honorable Supreme Court in Shreya Singhal, that the relevant threshold of reasonableness of restriction would differ from other mediums to the medium of internet. Your Lordship may kindly see
again Shreya Singhal.
Yes, yes. No. This is the contention that they raised in the written submissions.
Written submissions.
Yes. That was not accepted by the Supreme Court. It was not accepted by the Supreme Court. Supreme Court said, no, we reject it. The contention that was advanced today before your Lordships was the same contention that was advanced in Shreya Singhal, which was expressly rejected. They said, no, we don't see any difference. It may be that two different types of medium, but for the purpose of 19(1)(a) and 19(2), we see no difference. Because what was argued before your Lordship was, please give a wide interpretation to 19(2) when it comes to internet media. Please give a narrow interpretation to 19(1)(a) when it comes to internet media, whereas it is other way insofar as print media and electronic media is concerned. Why? We are more concerned about the speed with which information travels, and we are concerned with how many Supreme Court held that we do not find anything in the features outlined by the Learned Additional Solicitor General to relax the court scrutiny of the curbing of the content of free speech over the internet. While it may be possible to narrowly draw a section creating a new offense such as 69A, for instance, relatable only to speech over the internet, yet the validity of such a law will have to be tested on the touchstone of the test already indicated above. That the content of the right under Article 19(1)(a) remains the same, whatever the means of communication, including internet communication. We have also held that the wider range of circulation over the internet cannot restrict the content of the right under Article 19(1)(a), nor can it justify the denial. So, my lord, that argument runs in the face of the finding recorded by the Honorable Supreme Court, my lord, in Shreya Singhal. Now, my lord, your lordship may kindly see another paragraph which is relevant. Your lordship may kindly go to page 29, my lord, of our written submissions.
Yes.
If your lordship will be kind enough to turn to para 109. Now, my lord, there was a second chance for the union to argue about Shreya Singhal. That is, my lord, in Anuradha Basin's case.
Yes.
Anuradha Basin, my lord, was a newspaper publisher. No problem, my lord, about that. But the extent of the, no problem, my lord, about that. But the extent of the restriction that one can impose is the same. If it is foul so far as print and electronic media is concerned, it is foul for internet media is concerned. There is no distinction between the two so far that is concerned. Now, my lord, please see how the Supreme Court put it, my lord. Now we need to concern ourselves about the freedom of expression over the medium of internet. There is no gainsaying that in today's world, internet stands as the most utilized and accessible medium for exchange of information. The revolution within the cyberspace has been phenomenal in the past decade, wherein the limitation of storage space and accessibility of print medium has been remedied by the usage of internet. We need to distinguish between internet as a tool and the freedom of expression through internet. There is no dispute that freedom of speech and expression includes the right to disseminate information to as wide a section of population as is possible. The wider range of circulation of information or its greater impact cannot restrict the content of the right. Can it justify its denial? And after all, my lord, between Shreya Singhal and Anuradha Basin, it was just 5 years. It's in
5 years is too long a period.
Yes.
When you
diffusion. Therefore, the freedom of speech and expression through the medium of internet is an integral part of 19(1)(a), and accordingly, any restriction on the same must be in accordance with 19(2) of the Constitution. Thus, Anuradha Basin. Now, my lord, I just read a few lines, my lord. It was also said, you are doing it for business, you are earning money out of it. Please see what Supreme Court said in Anuradha Basin at para 34, that highlighted portion. Therefore, freedom of trade and commerce through the medium of internet is also constitutionally protected under 19(1)(g). Even that is protected. And of course, my lord, that argument that my learned friend advanced, that commercial speech is not covered under 19(1)(a), my lord, Supreme Court has already held that it is in the Tata Tata Press case, Supreme Court said, my lord, that it is covered. A commercial speech is also covered by 19(1). So, my lord, that argument, my lord, is covered against them. Now, kindly see para 35. My lord, I'm going to read only the highlighted portion. We are confining ourselves to declaring that the right to freedom of speech and expression under 19(1)(a) and the right to carry on trade or business under 19(1)(g) using the medium of internet is constitutionally protected. So, my lord, it's not as if just because it is internet, you have no protection at all. And then, my lord, kindly see para 10, our conclusion. Anuradha Basin independently reaffirmed the conclusion in Shreya Singhal that respondents disagree with. That's a different matter, my lord. There's an opportunity to argue that Shreya Singhal is per incurium before a bench of 5 honorable judges of the Supreme Court in Kaushal Kishore. Instead, in the written submissions, respondent relied on Shreya Singhal before the Honorable Constitution Bench and failed to contend that Shreya Singhal is per incurium. The relevant portions of the respondent's written submissions filed before Supreme Court in Kaushal Kishore are below. Now, my lord, I am just going to point out to your lordships, my lord.
ಅಲ್ಲ per incurium ಮೇಲೆ ಹೋಗ್ಲೇಬೇಡಿ.
ಬೇಡ ಬೇಡ ಇಲ್ಲ ನಾನು
ಅದು ಪ್ಯಾರಾ 134 ಮೇಲೆ ಬೇಡವೇ ಬೇಡ.
ಬೇಡ. I will not.
Because ಎಲ್ಲ per incurium.
Yes, my lord. I mean that was the in fact, my lord, the large part of the submission that were made on behalf of the respondent was to show how Shreya Singhal is wrong because they relied upon Reno, and then trace the entire law, my lord, in the United States, and then say all this has now changed. Therefore, Reno, on the basis of which Shreya Singhal was delivered, is itself not a good law in the United States of America, and therefore, why are you now looking at it? Therefore, please discard Shreya Singhal. They didn't say so in so many words, but that's what they meant to tell your lordships by taking the entire growth of law in the United States, which according to me is irrelevant.
No. The submission of the learned solicitor was that Shreya Singhal based its decision entirely on Reno of the United States. That's a submission.
It's correct.
And it's correct. So Reno itself is now diluted
in the United States.
In the United 5 US Supreme Court. Yes,
correct. Let me assume that the third submission, though, is not completely correct. I will show to your lordship that even in TikTok or in Ashraf, they never said so.
No, that was banning TikTok in United States.
Yes, banning. I showed your lordship that. I take only 5 minutes on that. I'm not going to take too long. Yes. But assuming that the first and second propositions are correct, still, today can we say, because the US Supreme Court itself
that I will see.
Submission. My submission, my answer to that is
no. That I will have to answer whether that is tenable, untenable, or whatever.
My respect to submission, it's an untenable argument. But obviously, they were reading a foundation to say.
Let me see if it suffers from want of tenability.
Yeah, according to me,
well, penning down. Yes.
According to me, it is completely untenable. That's my submission. My submission is that even if the Indian Supreme Court judgment is based upon a foreign judgment and a superior
Indian Supreme Court is binding.
It's binding. That's all that is important. And if all that, in fact, a large part of the submissions that have been filed before your lordships by the respondent, possibly, my lord, is relevant in a proceeding before the Supreme Court, where they want to have the Honorable Supreme Court to have a relook at Shreya Singhal. That is a different matter, my lord. Last, because today, whatever is the reasoning, my lord, the conclusion of the Honorable Supreme Court is what is relevant. Now, my lord, independent of that, for my lord, my submission on Shreya, my lord, is this.
Shreya Singhal.
Yes, Shreya Singhal, this is my submission. My lord, I don't think I want to.
That's, I think.
I have said everything, my lord. We have read those paragraphs so many times, we almost have got by heart.
Reread,
we almost got it by heart. Now, my lord, I just want to show to your lordships, independent of Shreya Singhal, that's 79. How do you read 79? My lord, I want to place for your lordships one point, my lord. Shreya Singhal, the 79 has, as your lordship sees, 79(1), which grants the exemption, 79(2), which says that exemption will apply in these circumstances. 79(3) says in these circumstances exemption will go. And just for a moment, my lord, please see 79.
No, that is loss of safe harbor.
Yes, that is. Now, my lord, please be kind enough to see 79 for a minute.
Yes. I'm there.
Yes, my lord.
Yes.
If your lordship will kindly see 79,
Mm.
kindly see 79,
3B.
3B, 3.
All right.
Provisions of subsection 1 shall
Shall
not.
not-
Provisions of subsection 1 shall
Shall
not
not
apply.
apply.
And if your lordships will kindly see 79(1),
Mm.
notwithstanding anything contained in any law of the time being in force,
Shall
but
not be liable for any
No,
third
my lord,
party.
I am now saying, but subject to the provisions of subsection 2 and 3. Now,
Proviso cannot control 79. Exactly. That's your suggestion.
and therefore it can't be that proviso,
Proviso cannot control 79. Exactly. That's your suggestion.
and therefore it can't be that proviso deals with a subject independent of the main section. If 79(3), my
So
lord,
if 79(3) is read as a proviso, the provisions of so and so will not apply,
yes,
then it can't override the main provision, that is 79. That's your suggestion.
that's my submission.
Yes.
That's my submission. Therefore, my lord, I contrast that with reading 79(2). At the most, it can be that 79(2) are conditions.
79 to enumerated conditions.
Conditions. Why did they then put 79(3) separately? I ask myself. Because though it was drafted in that way, putting 79(3) separately in that manner, it says it shall not apply. In other words, it was eating into 79(1). Now, my lord, if it is eating into 79(1), can you say that the proviso confers a power?
If I construe it to be a proviso,
Yes,
I
of course,
accept
of
this
course, of course,
submission.
of course,
Yes.
of course, of course, of course.
Because on the look of it or on the purport of it, it does not, it's not a proviso.
It doesn't say that way.
No, it's not a proviso though, but if it is to be interpreted